A contract is a promise or a set of promises enforced by law, a legally enforceable agreement. Requirements to form a valid contract. A contract is formed when there exists one, mutual assent, meaning the meeting of the minds, demonstrated by an offer and valid acceptance, determined by parties' objective, not subjective, manifestation of assent. 2, consideration, a bargain for exchange of legal value between parties. And 3, no defenses to form a contract formation. So no defense to formation exists that would invalidate the contract. Void, voidable, and enforceable contracts. If there is a valid defense to contract formation or enforcement, a contract may become void if contract never had any legal effect, voidable if one or both parties may elect to void the contract, or unenforceable, otherwise valid contract that is unenforceable because a defense applies, such as incapacity or statute of frauds. Bilateral contract is the exchange of mutual promises. Each party is a promisor and promises. An example is an offer to sell his car to B for $5,000, and B promises to purchase A's cars at that price. Unilateral contract is an offer that requires performance as a matter of acceptance. Offer promisor agrees to pay upon completion of the act requested by the promisee. Once act is completed, contract is formed. A promisee to pay B $100 if B paints A's fence. B is not obligated to paint A's fence, but if B does, the contract is formed and A must pay B $100. A quasi-contract, not a contract, but rather a restitution remedy designed to prevent unjust enrichment, is an implied in fact contract arises if there is an unenforceable or non-existent agreement, but one side has realized the benefit. Look for 1, where a plaintiff has conferred a benefit to defendant. 2, plaintiff reasonably expects to be paid. 3, the defendant knowingly accepted the benefit, and D, defendant will unjustly be enriched if plaintiff is not compensated. Most contracts are governed by either common law or the UCC. Common law applies to most contracts except sale of goods. Common law. Any contract not involving the sale of goods should be treated under common law contract principles. Generally applies to contracts for real estate or services. UCC Article 2 governs the sale of goods. If both parties to the contract are merchants, the UCC has additional special rules, such as acceptance with additional terms. Mixed contracts, for contracts involving both goods and services, the predominant purpose of the contract dictates the applicable law. Exception: if the contract terms divide payments between goods and services, apply the UCC to the sale of goods portion of the contract and common law to the remainder. Duty of good faith. In both UCC and common law contracts, an obligation of good faith is imposed on the performance and enforcement of a contract.